Graphene is a unique nanoscale form of carbon that is disrupting legacy materials, bringing step-change improvements in performance across a wide range of industrial and consumer applications. From energy storage and electronics to everyday materials, graphene enables products that are better, stronger, and lighter, while increasing durability and improving sustainability. Graphene is leading the era of new advanced materials.
The following is a presentation that was given as part of a 2-day virtual Graphene Investors Conference, hosted by the Graphene Council.
Thank you very much, Terence. I hope everyone's been enjoying the pictures so far. So, like Terence said, I'm here to talk about IP issues. So, first of all, I'm Jason Tang. I'm a partner and patent attorney from Clarkson, a European intellectual property law firm. So as a firm, we have offices in multiple European countries, and we can advise on all matters relating to IP law in those countries and also on a European-wide level. So today, obviously, IP law is it's a very wide subject matter area, but I'm going to focus on key issues which I feel are very important for materials companies, specifically IP due diligence when investing in material startups, and also the European market's legal landscapes, for materials companies that are looking to work across Europe. So the first IP legal issue relates to key considerations for IP due diligence for investors looking to start up in materials technology companies, or indeed corporations that are looking to acquire material companies. So what happens in the IP due diligence process? So if I had to summarize it in one question, the key questions as I see it will be, is the investor's business plan achievable for the target company? So surely, when an investor or a corporation is looking to invest in a material startup, they are looking to see whether they can get a return on investment, or whether that materials company fits into their business plan. And so specifically from an IP angle, is there anything in the current IP portfolio and future IP portfolio which could help or hinder or otherwise impact on those plans? And if the goal is simply to monetize the IP or to achieve commercial success, what are the IP factors that are either going to help or undermine the likelihood of success? Now, drilling a bit deeper into that question from an IP perspective, here are some of the main headers and topics that will be considered during the due diligence process, and this is beneficial for not only for investors but also potential investees. What I'll look at is, what is the current commercial state of play? Has that materials company been selling their product? Do they have any existing licenses? Are they collaborating with other companies, universities, and so forth? And any other relationships of the target, because is the target company a standalone company, or are they potentially owned by a company, or is there another investor who has a stake in the company? Now, I think this is particularly the case with materials companies who will be bound to be working with a large number of third parties, whether it's customers, suppliers, researchers, or even universities who help validate their technology. So we look at which partners are involved, how much control those partners might have on the target company's IP, and has this control been formalized in some way in the form of a collaboration or even licensing agreement, and what are those terms? And looking at all these factors, you can assess how this will impact on how the target might achieve the investor's business plans, because clearly, when we talk about control, if let's say a third party may be able to control the IP in some way, they could potentially hinder the investor's plan. Next, we look at the next point. Same slide. Sorry, Terence. We identify and assess the IP portfolio to determine whether that IP actually matches the target's business plan, or indeed the investor's business plan, including the patent scope, the territorial coverage, and the market. So what IP assets does the target company have? Does it cover what they do commercially or what they plan to now and in future? What territories do they cover? Do they cover only the home market? Do they cover where it's manufactured, where it's being sold? And again, we go back to the business plan. Does it match the business plan? Once you've identified the portfolio, can you improve on that portfolio? Or actually, once you look through the portfolio, there might be some old IP that's now irrelevant. And so what are you doing with it? And this is really important for materials companies is if you have any existing IP rights, are they broad enough to allow you to pivot their technology? Because we know that technology pivots happens all the time, or new markets open all the time. Are those existing IP rights broad enough to expand to those technology pivots and new markets? And then, in addition to registered IP rights, we need to look at non-registerable IP, such as know-how, which we know is very common in materials companies. Now, non-registerable IP may not be at the forefront or as obvious as registerable IP, but if that know-how is absolutely crucial to the business, because we know that when it comes to the materials world, it's not just about having patents. There's a lot of know-how that goes into the processing, supply chain, and so forth. What contingencies are in place to account for those people if they happen to leave the business? So identify the key individuals holding the know-how and expertise, and actually record that know-how so that if that key person leaves the business, the know-how remains within the target company. And this is not just on the innovation and R&D side, it also includes the commercial team, the business team. And then finally, what do we look at? We look at awareness of third-party rights, both for current business areas and any areas that you may choose to pivot into. Do you know what third-party rights might exist and your freedom to operate? Are you already aware of any existing IP that could impact on the ability to manufacture or sell the product in a particular territory, and have they sought advice? And have they looked at future areas of business and how crowded that field is? Again, which areas are of high risk to the company? So again, this slide outlines useful questions to ask a target company during the due diligence process. So to help establish these key areas, these are some example starting questions that an investor might want to consider asking a target company in order to have the necessary information and documentation to start a proper IP due diligence evaluation. Do they have IP strategy documents that have a commercial strategy instead of just a list of the IP rights? Do the IP rights map to what they do? Are they aware of the status of the IP rights? Number two, which territories are important and where it might be copied, because that dictates where the IP rights should be registered. Has the IP been valued or assessed in any way? And perhaps is there some sort of insurance to cover the IP? And then also, how organized is the IP data room? Again, the IP data room is not just a list of the rights. It could include collaboration and licensing agreements. It could include a record of know-how. Having that an organized IP data room means that if the information is required at a moment's notice or something goes wrong, that IP data room can provide that information instantaneously. And also the investor knows exactly what IP they are buying. And then fifth point, which is absolutely important, is there a clear chain of title for all the IP rights? Because the last thing an investor wants to do is invest in the target company only to find out that the IP belongs to a different legal entity. So the target should always prove that they own the IP. After asking those questions, how do you weigh up the answers? No, we look for good indicators of good practice, and what we'll look out for, and looking out for these good indicators to help us figure out the relative strength of the IP position and whether it helps meet the business goals. So, what we want to see is that we want a strong legal position, good management, commercial sense, and mitigation of risk. So we might look at them having filed strong and relevant IP applications, which provide good legal protection, broadness and fallback positions in patents, which allows for technology pivots, which in turn provides commercial flexibility, strategic selection of territorial coverage. They are covering the key markets in which they're doing the manufacturing, or whether they're doing some processing step, or perhaps where they're selling it. Also, a willingness to actually either sell or license the IP that's no longer relevant to generate revenue streams, or abandon IP that's not being used to save on costs. And then also, I think finally, like I said, awareness of third-party rights and having a strategy to deal with such third-party rights. We talked about the good stuff, but what about the bad stuff? You want to identify possible red flag issues. Obviously, if there's no red flag issues, great, but you have to be on the lookout for them just to be sure that, whether they exist or not. So during a typical IP due diligence process in technology companies, the more general failings that we have seen is a company might have what seems like a robust IP strategy, but it simply does not map onto their technology and their business plan, or they've not actually updated it. So there is no relationship between IP strategy and business plan, which means that the IP strategy may not fully support the business plan. It could be that they have an excessive IP portfolio. They've filed too many patent applications, or they've covered too many countries, and they've not considered whether it actually provides the company with utility, and it ends up costing a lot of money for very little gain. The IP doesn't cover the products or services being exploited, so that means that your legal position is not as strong. You might think your products or services are being protected, but actually they are not. And where third parties or these spin-offs involved, there is a missing chain of title or missing assignment documents, which means that the target company might not own the IP at all. And then finally, no to little downstream IP budget considerations, which creates cost risk for the investors. So this has been a quick overview of the key considerations when it comes to investor due diligence. So, this is what investors should look out for when they're looking to invest in or acquire a materials company. And on the flip side, companies that are looking for investment or looking to be acquired, they should look at these points, because these are the points that, an IP lawyer myself will be looking out for during the IP due diligence process. So looking through these slides will help you prepare for such a process. So we spoke about key considerations for IP due diligence. Now, whilst there are a lot of IP issues that might be important in materials companies, I would like to focus on IP issues at a European level. It's because a materials company that's entering Europe, they're unlikely to just choose one or two countries. They're likely to look at Europe as a market as a whole. So I think it's quite important that materials companies are aware of a relatively new European patent court system, which comprises a new patent right, which we call the Unitary Patent, UP, and a court system called Unified Patent Court, UPC. Now, understanding this new legal entities will help you understand the legal impact that a materials company might have if they are operating in the European market, not only in terms of enforcing against patents, but also defending against patents. Because a materials company might go, oh, you know what, I'm not looking for European patent protection, so I would not be affected. But another company may well have a unitary patent. So understanding how the system works will put you in a position ready to deal with any such legal enforcement of those patents. So, what is the new European Patent Court system? So it came into force June last year, and this is a new system for obtaining and enforcing patent rights in Europe. Now, there has already been a long-standing system called the European Patent Convention, which allows a company to apply for a European patent. And once the European patent is granted, that European patent can be granted, it can be converted into different national European patents, and each national European patent has legal force in each individual European country. Now, that is what we call a classical European patent. Now, on the other hand, the unitary patent, UP, is a patent right, a singular patent right that provides protection across multiple European countries, currently 17 countries, which means that, instead of having 17 different patents, you have this singular EU-wide patent. And the Unified Patent Code is this new multinational code for enforcing and challenging unitary patents. So, how does this relate to a materials company? And what are the important decisions to be made by any users of the European patent system, whether you're using it to enforce a patent or defend against a patent? Because you may well go, oh, wait a minute, somebody has I'm operating in, let's say, Germany or Italy. I'm not going to be affected by a company opening in France. But if they have a unitary patent which will cover France, Germany, and Italy, you could well be affected. So what are the considerations to have to be made by materials companies? Will the unitary patent, will it provide you with the required territorial protection if you're looking to manufacture or sell in Europe? Do you understand the unitary patent system? Are you ready to enforce one or defend against one? And if that's the case, it's like, and should you be choosing a unitary patent covering multiple European countries, or should you choose national patents that provide separate protection? Now, this is an interesting question because on one hand, if you choose to go for a unitary patent that covers all these European countries, it provides great savings in terms of cost. But the risk is that unitary patent can be challenged centrally at the Unified Patent Court, and it could be knocked out by a single set of court proceedings. While having different national patents means that if somebody chooses to challenge your patents, they would have to challenge it in different courts, which increases their litigation costs and basically makes it harder for them to challenge you. So, I guess in short, if a materials company is targeting the European market as a whole and patent protection is key to their strategy, have they considered the impact of the unitary patent on their company? Next, so we've spoken about the unitary patent, which is the singular patent right that covers different European countries. But what about the Unified Patent Code? It's a single code for enforcing and challenging unitary patents. It has jurisdiction over unitary patents, but also potentially over classical European patents, i.e. the old European patents, in certain states, unless there's been an opt-out of those patents. Since the court system is a complicated structure of national, regional, and central divisions, it provides the potential for forum shopping, not only for the for the claimant. So from that point of view, I think if a materials company if they are knowingly entering a very litigious area, I think knowledge of the unitary patent, Unified Patent Code is really important. So at present, there is the possibility of litigation in one or more states, but it may change. For a unitary patent, this may be limited prosecution before a court or UPC, and at least during a transition period, there may be a balance of UPC level litigation and national litigation if it's choosing to proceed with a patent. So again, it's if a materials company is entering a litigious area, having knowledge of this allows them to prepare accordingly, and more importantly, having the appropriate budget or legal insurance in place. For materials companies, a single court system can provide the following benefits. It will lead to a more uniform application of law throughout the EU, currently across 17 EU member states. And this gives certainty to a materials company's IP enforcement or defense strategy, which means they can plan accordingly. And especially given that targeting the European market as a whole is very complicated. And if a materials company decides to litigate, let's say they decide to enforce a patent, the Unified Patent Court allows them to litigate before one court to achieve an EU-wide result currently across 17 countries, such as an EU-wide injunction and EU-wide damages, which can be very valuable and cost-effective for claimants. So this might be very appealing for enforcement if you are trying to enforce it against a territory infringer that is infringing across multiple territories, because either they are making or selling in different places, or they have a network of importing and selling across Europe. Obviously, this is more appealing compared to the old system. And getting that single court decision on liability and infringement that can be enforced in all of the member states of the unitary patent system. And this can save on litigation costs and improve your ability to recover damages. Damages, again, is very, very claimant friendly. And again, centralizing a single action means that you do save on cost and complexity, and also time spent in dealing with court cases. So by having a unitary patent and availability of the Unified Patent Court to enforce unitary patent protection, it does create uncertainty. It does create some uncertainty for potential infringers, which may act as an additional deterrent to competitors. So since materials companies, they often target Europe as a whole as opposed to individual countries, having an understanding of European-wide IP protection system, including the unitary patent and the Unified Patent Court, is extremely critical. Now, I should mention that there are some major countries such as Spain, Poland, Croatia that are currently not covered by the unitary patent system. In time, some of these countries may start to join this system, and it's worth keeping an eye on those. So, and this is just a graphic showing the current UPC member states. Like I said, that this will change in time. There's, I would say Spain will be a major omission, and they are likely to be a major omission for the foreseeable future in terms of where the unitary patent does not apply, and separate protection will be required in those countries. And obviously, when it comes to non-EU countries, separate patent protection, such as the UK, Norway, Switzerland, separate protection will be required in those countries. So yeah, so that's the end of my presentation. We've covered key considerations in IP due diligence, and also the new unitary patent and unified patent court system. Hopefully this has been useful for materials companies that are in the European market or actually looking at the European market. So thank you very much for listening to my presentation. My contact details are available in the slides if anybody wants to get in touch, or you can get in touch with me through Terence. Thank you very much.
Jason, thank you so much. Really appreciated that. And your expertise in this area is obvious.
Yeah.
One of the things I wanted to point out, and we have just a few minutes for a chat, because we'll go to our next presentation at quarter two. So we do have a few minutes. I wanted to get your perspective on something. First of all, at least my observation has been that even if a company is, let's say, US-based or Canadian-based or Australian-based, or vice versa, European-based graphene-related company, our expectation and observation has been sooner or later, probably sooner, they're going to be operating in at least the European and the US market, or the US and the European market. We don't see, what I'd get to is that if somebody's listening to this presentation, and I know you were covering the European patents, and they're trying to say, well, I'm looking at a North American company, this isn't relevant to me. I would argue that it's almost certainly the case that that sooner or later it's going to be relevant. What would you say to that?
I think most certainly. I think yes, you're right, because the thing is, it's a global market, and thing is, companies who really look forward, they can really build that into the IP strategy. Yes, it may be that they go like, look, Europe's not in our sights for at least the next 2 or 3 years, and it may be that they don't apply for European applications to save on costs. But that consideration of whether to protect in Europe should always be in there, because things can change at a moment's notice, and opportunity might turn up, and can they react quickly enough to protect themselves in Europe? Or it may be that if they say, look, we'll never step outside Europe, but a European company may well come and say, look, I'd like to work with you. Do you have any IP rights in Europe? And the thing is, if let's say they had no IP rights in Europe, then the European company say, oh, that's fine. Thank you very much. We'll just copy what you do. So I think it's not to say that non-European companies should always protect themselves in Europe, but the possibility of protecting in Europe should always be in the IP strategy so that they can react at a moment's notice.
Yeah, I mean, it's clear any major application that's going to be relevant in let's say the U.S. market, let's just pick that, is going to be relevant in another advanced economy like in the European Union. The other last question I wanted to ask you and get your perspective on, we've seen, obviously a lot of graphene companies or materials companies tout their IP portfolios as a key asset and a key strength. And then layer on top of that, as you and I know, because we talked about this recently, since 2004, depending on how you're able to measure it or categorize it, there's at least 150,000 graphene related patents, which makes quite a thicket to walk through to figure this out. My question to you to get your perspective is, how does even a sophisticated investor evaluate the utility of a graphene related patent? And what I mean by that, it's relatively easy to say yes, no, do they have a patent? Maybe less easy to say they've got chain of custody, right? They've got chain of ownership. But what is the actual worth of that particular value?
I mean, the thing,
technically or scientifically.
I mean, I first of all, I mean, what's the worth of an IP, right? First of all, the worth is always, what's the commercial value? Does it support the business plan? But then you go like, what do we mean by that? First of all, does it map on the technology? I mean, I could get a patent for a new invention, but if it doesn't cover the technology, whether it's the process, the materials, or the end product, that IP right is worthless. Then, does it map onto it? Does it cover it? If the question is yes, I guess my next question is it broad enough? Because if you end up with such a narrow patent, and I can easily design around it, you could argue that patent is nearly worthless. Because yes, it is a patent that covers technology, but it's potentially worthless. So those are the considerations. It's like, I guess I would say that because with an IP right, the question is, if I had to enforce it, can I enforce it? That's the question you ask. Because if you say I cannot enforce it, then it's not a strong patent at all. But also something to bear in mind, and I know with a minute left, is that sometimes having good patents in your portfolio gives you leverage, because against another company that may have patents as well, and they may be cross-licensing opportunities there.
Jason, thank you so much. Appreciate you joining us from the UK.
For more information on market opportunities and to connect with experts, contact the Graphene Council at thegraphenecouncil.org.